Mr. Dennis Tan.
Thank you, Mr. Speaker. I declare my interest as a lawyer in private practice. Mr. Speaker, this is the 14th time the so-called Temporary Act in its various forms has come before Parliament or its predecessor for renewal of another 5 years. At the last and 13th renewal in 2013, this Act was extended for 5 years from 21st October 2014, which means that it is only due to lapse in October 2019. The most controversial and draconian aspect of this Act is the fact that this law puts people behind bars without the usual due process. Like the ISA, it is a controversial exception to our legal justice system, which usually requires every person to be charged, tried, and convicted in court before he can be detained in prison. To take away someone's liberty like this is not something we should ever take lightly too. Under the existing Section 30, the Minister can order the detention of a person for any period not exceeding 12 months if the Minister is satisfied that it is necessary that the person be detained in the interest of public safety, peace, and good order. Under Section 30, the Minister can also make an order for a person to be subject to the supervision of the police for any period not exceeding 3 years if he is satisfied that it is so necessary. We should also not regard supervision order lightly, as such orders impose restrictions on a person's movements and activities and may impact on his work and liberty. The time limits for detention and supervision should also be viewed from the perspective that each order can be renewed indefinitely. This must never be taken lightly. Mr. Speaker, in each of the previous occasions when Parliament debated the initial bill and the subsequent renewals of the Act, many members have spoken up about their concerns about the undesirability of this Act and how soon Singapore can mature to a society where we can do away with this Act. Many members have also spoken in agreement with the Minister of the day on variously the rationale for extending the Act to deal with the concerned crimes of criminal groups of the day. I read from ministers and MPs' speeches in the Hansard that this range from secret societies, gangsterism, drug trafficking, murders, extortion, and protection rackets, to, in more recent years, money laundering, loan shark syndicates, organized crimes, and global match fixing. There was also mention of arguably activities which are traditionally not regarded as criminal, such as prevention of strikes and lockouts, as well as communist domination. Mr. Speaker, today at the 14th renewal of the Act, we are not asked merely to consider the extension of the Act based on identical provisions. The Ministry is proposing some important amendments. My biggest concern with this bill is with the proposed amendment in Section 30. The bill proposes to make every decision of the Minister on a matter in the current Section 30 final. The explanatory note to this bill details 3 matters: that a person has been associated with activities of a criminal nature, that it is necessary for a person to be detained in the interest of public safety, peace, and order, that it is necessary that a person be subject to the supervision of the police. These are the applying criteria leading to the Minister making a decision to make a detention or supervision order. The proposed amendment is a disconcerting change to the existing provisions of the Act. I take the view that the proposed amendment will take away the existing rights of detainees under the current law to seek judicial review by our courts in respect of the appropriateness of the Minister's decision to order any detention or supervision. Specifically, whether the Minister was correct in deciding that the person was appropriately associated with the type of criminal activities coming within the Act, or whether the Minister was correct in his decision that it was necessary for the person to be detained in the interest of public safety, peace, and order, or whether the Minister was right in deciding that it was necessary to subject a person to the supervision of the police. I'm concerned that, if passed, the Minister's decision on these aspects of his order can no longer be challenged, even if the Minister's decision exceeds the scope of his powers. Now, in respect of the Minister's clarifications and his comments earlier, may I seek the Minister's clarification whether the amendment that the government is seeking would bar the courts from objectively reviewing the matters that the amendment wants to now declare the Minister's decision as final. Until now, judicial review is available to detainees to challenge the Minister's order if, for example, the Minister had not acted within the scope of his powers. An order can be scrutinized by the court if it is illegal, irrational, or if there is procedural impropriety. This is confirmed, again, by the Court of Appeal case of Tan Sik Eng and Attorney General. As the Court of Appeal held in that case, the court's power for review is not to review the truth of the allegations of fact found in the grounds given for detention, but to scrutinize the grounds given to justify the detention to see whether the Minister acted within the scope of his powers. Let me attempt to summarize what the Court of Appeal has stated on the scope of the Minister's powers, as it is a helpful reminder of the present principles governing the scope of the Minister's powers under the Act. 1. The normal course for dealing with criminals will be by way of prosecution in court, and recourse to CLTPA will be in limited circumstances, when normal legal processes could not be relied upon due to reprisals to witnesses. 2. The court listed certain specific types of crimes and stated that the offences must have the following unifying characteristics: threat of violence and reprisal to intimate witnesses, detainee is associated with a criminal activity of a serious nature, not just any criminal activity. The offences must pose harm to public order in Singapore. The Court of Appeal stated by way of an example that activities of gangsters, secret societies, and syndicated crime gangs involved in violent crimes all affect peace, safety, and public order. In the Dan Tan case, the Court of Appeal allowed his appeal and quashed his detention order under the Act. The court held that the facts and activities provided in the grounds were not sufficiently serious to fall within the scope of the Act, and also that it was not clear whether the activities stated had a bearing on the public safety, peace, and good order within Singapore. The Court of Appeal's decisive judgment confirmed the importance of the court's role in ensuring that the minister's order must fall within the scope of his powers under the current law. There's no doubt that the proposed amendment is a response to the court's decision in Dan Tan's case. Judicial review is an integral component of the rule of law. Chief Justice Sundaresh Menon said in his speech on the rule of law at the annual meeting of the American Law Institute in May 2016, when he commented on the court's judgment in Dan Tan's case, and I quote, "Judicial review is the sharp edge that keeps the government action within the form and substance of the law," unquote. Is this sharp edge going to be taken away from the existing Section 30 of CLTPA by our amendment today? New Zealand High Court Judge Justice Matthew Palmer, in his speech touching on rule of law and judicial review, as the Kwa Geok Chu Distinguished Visitor at the NUS on 20th January 2016 said, and I quote, "I consider that the availability of the law of judicial review to test the legality of exercises of public power is a direct manifestation of the rule of law. If a public body purports to exercise public power in a specific instance, those concerned with the exercise must be able to ask an independent body, the courts, whether the exercise of public power accorded with law. If it did, no harm is done by testing the question, and indeed public confidence in law and government is enhanced. If an exercise of public power were not made according to the law, then the rule of law requires that be addressed, as it is when any other decision maker acts inconsistently with law. To leave the decision to the executive branch untested is to leave the effective determination of the law, a judicial function, to the executive," unquote. I agree with what Justice Palmer has said. Now, is the change in Section 30 really necessary? Is it right or fair to dispose of such safeguards now? After 13 renewals, is this not a step backward? I will leave this section, this point on this note. I next have a clarification for the Minister. I note that the Minister has told us earlier that about the latest development that judges will be chairing the advisory committee. But I seem to recall that what you have said may be different from your suggestion in Parliament in 1989. Now, the judges chairing the committee, under the present system, the judges chairing the committee, the advisory committee with the judges as the chair will still have to report to the cabinet, who will advise the president. That's what I understand the present system is. And may I just, for ease of understanding, may I just quote the minister's remarks in his speech in 1989 at the second reading of the renewal bill then. And I quote, "The Internal Security Act can be justified under our circumstances. For the CLTPA, there may be more questions, and it has to be accepted that we cannot ever eliminate crime. We can only control it within acceptable, tolerable limits. So the minister has to focus on that and tell the House whether at the present stage the situation is such that secret societies, gangsters, the original justification continues to exist at the same level of seriousness which justifies powers of administrative detention. If it does so, then I would still ask that you consider one structural change to the existing provision. This is to ensure that CLTPA is not abused. At present, the CLTPA is such that the minister decides on the detention. The advisory committee advises the president, and the president has ultimate powers. I would suggest that the minister still decides on the detention, but perhaps powers of review be given to the courts. The reason I say that is if the minister takes a reasonable view on the facts that a certain person poses a danger, then presumably the act can be worded such that the courts can look at the facts, the reason for the minister's decision, and then come down on the side of the minister. So if the courts disagree, if the judges disagree, then again the minister's decision will be overturned. So remove it from the president to the executive and give the power to the courts. This is not to suggest that it has been abused, but only to prevent CLTPA from being a convenient route where the police do not have sufficient evidence against common criminals to prosecute them in court, and therefore use CLTPA. The minister is a busy man. He has to rely on the reports that are put up to him by his police force. And the police do not have the monopoly of virtue and morality more than any of us. So that is an important point, and that particular provision worries me, unquote. So I'd like to seek the minister's clarification whether what the minister have in mind as he introduced a short while ago, whether it's similar to what he has said in his speech in 1989, but it seems to me to be slightly different. And if it's different, perhaps would like the minister to share with the House why does he not propose to the House that we go the whole hog with what he suggested in 1989. I next move on to the suggestion for the reduction of reporting period to advisory committee. Mr. Speaker, currently Section 31 requires the minister to refer every order to an advisory committee within 28 days of making the order. I would like to ask the minister to review the timeline of 28 days. Why do we need 28 days? It seems like a long time for such a referral. I'm sure that when an order is made by the minister, the public prosecutor and the police would have and should have already carried out proper investigation and inquiries to reach the conclusion that an order is necessary. So the paperwork should not need much more time after the order has been given. I would like to propose that in the interest of justice, this period should be reduced to 14 days. This will also be in line with the extended period of detention accorded for police investigation under Section 44(3) of the Act. Finally, I read in the Straits Times report of 10 January 2018 that the obligations and restrictions under police supervision orders will be shifted to a subsidiary legislation, and that this move will give the minister greater flexibility in imposing the necessary conditions and curbs. I would like to ask the minister what will be the changes in the conditions and curbs and the so-called flexibility that the minister is seeking. Mr. Speaker, in closing, I do not agree with the proposed amendment in Section 30 of the current Act, and for that I'm unable to support this bill. Thank you.